Thanks for joining me on the Meg Ellefson Show. My guest during this hour from Institute for Reforming Government, easy for me to say, General Counsel, all-around cool guy, Jay Curtis. I just threw that extra title in there.
Yeah, I'm going to have to tell my kids that one. I don't know if they would agree, but...
Yeah, well, someday they might. So just give it a little time. I've got two 20-something-year-olds, and they kind of like their mom. So I think they love their mom. So, and they call me a mom, too. They don't call me that other term that only Tony Evers and his administration use.
Yeah. I mean, inseminated person, that was a new one.
Yeah, so insulting. And anyway, and of course, we could go on and on about it, but hey, let's talk a little bit about, and I want to give you time for a couple other topics, but I shared that story that I wrote last week about our Attorney General and his obsession with a small town mayor here in Wausau, moving an unsecured ballot box into Wausau City Hall, and then what appears to be, I don't want to use the wrong words because we were just talking about how we can't false advertise, but what appears to be, I don't know, one could wonder if there's any collusion going on between the Attorney General's office and the ethics board here in Wausau.
Yeah, I read your article, Meg, excuse me, and I think it provides a really good analysis, and I think asks some key questions, relating to this situation. Look, the mayor, I don't know. I would not have advised him to just unilaterally move the drop box. There was probably a better way to go about that. But even if it was just a mistake or kind of a quick decision, for there to be multiple investigations. And look, we talk about this concept of lawfare. There's a time and a place when there's a need for investigations. Even on the civilian side, one of the things I have done throughout my career is assisted municipalities with investigations. Right? There's going to be times when there's been a decision made by somebody, some employee, somebody in the kind of the personnel area that needs to be reviewed. That happens. I get it. But when you're the Attorney General, and already the local unit of government is handling this to come in with agents and execute a search warrant when the wife is at home with the grandkid and taking phones because again let's just say he made a uninformed decision. He should have maybe worked through the process a little better. That is a unbelievable exercise of authority, and it begs the question, kind of what is driving this? And then I think, as your article points out, if you're the Attorney General, I would think you'd want to be a little more careful when you're communicating with somebody at the local ethics kind of committee level. And it sounds like he responded and said, we can't talk about that case, but why in the world, knowing that there's concurrent investigations going on, why in the world would he have made that call? Just move on to the next person on your list. So at a minimum, it looks really bad. And then, you have to wonder, why was he making the call? Why did he make it the day he made it? But again, I think, your article kind of lays everything out. Other than reading your article, I don't have any more information. It just begs the question in my mind of, we need to get out of this kind of this lawfare realm. We need to stop viewing the law as a weapon for political opponents. It should be applied objectively, and frankly, for situations when somebody is knowingly making false statements or actually violating an important criminal statute, or civil, right, depending on the circumstance. But executing a search warrant at somebody's home, and then, from what I understand, based on your article, still sitting on the cell phones and laptops, is I'll just be blunt, it's absurd.
Outrageous, I guess. I don't want to put words in your mouth, and I guess it also begs to be asked, how impartial can either one of those two be? Josh Kaul and or this vice chair of the ethics board in Wausau if it's obvious. I mean, he volunteered this information that he, number one, had received a call, and which would make you look into, which I did, what types of campaign contributions he's made. He was a supporter of our former mayor, so clearly he's not a fan of our existing mayor by the sheer fact that he beat her in the last election.
Right. Well, and as your piece points out, I believe somebody else on the commission who kind of had what appears to be a similar conflict did recuse. Right. So there's already the precedent for doing that. Right. I mean, if you're sitting on some sort of committee or commission like this, reviewing an ethics situation, again, I've been involved in these. You need to be able to be objective, and if you can't, you need to recuse. But it also, I think, leads to the problem of when you have something that's so politically charged, and it's so obvious that this was really more of a political attack. You should be asking, from kind of the municipality standpoint, whether or not this is something that really needs to be reviewed through that ethics lens, and then certainly from the state standpoint, if there's already a local investigation taking place, it does not appear like this state investigation driven by the DOJ was really necessary.
All right, before we run out of time, let's talk. This actually caught my attention anyway, but your latest release about Court Watch. And I mean, if you could just do a quick refresher on what Court Watch is, as defined by Institute for Reforming Government, and then your recent piece about will the Supreme Court make Wisconsin, Alabama North again? Oh, yikes.
Right. So every week we are doing a primer. We're calling them primers. They're really nice, simple, 2 to 3 page documents that kind of lay out an important issue, both kind of what if there's cases that the current, right. So we've had a progressive majority since August of 23. That's when Justice Protesewicz took over and was sworn in, right. So we have some examples and we try to highlight those cases. But then also, when the court hasn't ruled on a decision, and I think that's an important point, there are numerous examples, and we've tried to point that out, where this court appears to be definitely sitting on cases. And I think it's hard to not conclude that on some of these cases that they may be sitting on them strategically and waiting to issue decisions after the election. The 1848 abortion case that everybody's talking about, right? That they probably could have ruled on that some time ago. They haven't, and I think they're sitting on that for political purposes. So if you kind of go through those, we've tried to highlight the areas where even if the progressive majority has not already issued a decision, where could they? And so we've issued primers on school choice. That's an interesting one because there actually was litigation, if you recall, back in, I think it was late 23, early 24, somewhere in that time frame. There was a lawsuit filed by the gentleman from Minocqua. That direct petition was denied. So strategically, the court didn't want to take that up, and frankly, I think it's because school choice is wildly popular in Southeast Wisconsin because it's giving kids a chance to get a good education and get out of the MPS system. You look at Act 10. I think we've beaten that horse, right? We have made it very clear. Look, if Act 10 is overturned, there's going to be a significant either increase in property taxes, but I've been reminding people we still have levy limits in place, and so assuming there's no adjustment to the levy limits, there actually may not be a huge spike in spending. But what you probably will see is a significant reduction in government employees, services, and almost an unintended consequence. Now, you could say, we need to shrink government. But again, that's not really the message you're seeing from the left. They want to paint this picture that we're going to go back to the pre-Act 10 days and every condition of employment will be bargained over, and public employees won't have to make any contributions to their world-class pension or health care benefits. But again, if we have levy limits, there's going to be constraints in there, and I'm not sure they're going to like the outcome. And so we talked about that. We talked about voter ID and election integrity. And then this week, with the time we have left, I definitely want to highlight this week's primer, and that relates to kind of the business climate. Look, I love Alabama. I actually have to go down there for training pretty frequently. It's a great state, but they don't have a great climate when it comes to personal injury, any sort of malpractice caps, which makes insurance extremely expensive, makes it hard for practitioners to actually practice. And so Wisconsin was in that position. We highlight the Alabama North because that's actually from a headline of an article, an opinion piece from the Wall Street Journal in 2005, because we were in a really bad spot. If people recall, under Chief Justice Ellefson, there were really two critical decisions. One related to kind of the medical malpractice caps. We talked about rational basis, right? So it's a perfect example of a liberal court finding there was no rational basis for the legislature to cap medical malpractice damages. Herndon is the case. So that was 2005, which resulted in increased insurance costs, right? I mean, we talk all the time about a shortage of medical practitioners in rural areas. It doesn't help if there's no caps on damages. And then the second one was this just really, frankly, insane risk contribution theory, where you had these manufacturers where plaintiffs were able to bring cases against them, right? And there's a very basic principle I think, frankly, everybody in your audience knows. Like if there's going to be a tort, right? So a claim that there was some damage caused by an individual or manufacturer, right? You have to actually prove that defendant caused the injury. And in 2005, the liberal Wisconsin Supreme Court, basically under this risk contribution theory that was advocated by Justice Ellefson, that, well, I mean, if you were part of an industry that possibly contributed to this injury, you can still be held liable. Which, if you're a manufacturer, is just insane, right? So, I don't paint. You produce a paint. I think that was the issue, and there was I think some chemical, and so not a good situation. But you would certainly say, well, whoever produced that product, that should be the one liable. And they weren't able to prove that. And the court basically said, well, that's okay. As long as you were part of that industry, we think you were partially liable. And so that caused a really negative business climate. And it was Governor Walker, Lieutenant Governor Clayfish, legislative leaders that reined that back in 2011. Act 2, right? So we talk about Act 10. We talk about Act 21 with the administrative law reforms. Act 2 is another major reform passed in 2011 that reined in these implemented these caps, made sure there were clear standards for expert witness testimony, made sure there were safeguards against industry-wide legal liability. So making sure, like, look, if you have to be proven to have caused a damage. I mean, so what was the impact of that, right? Insurance premiums went down. Wisconsin in 2010 was ranked the 41st best state for business. By 2017, it had risen to a top 10 status. Right, so there's real-world implications. There's real costs for businesses when we don't have a friendly business climate. And that's not to say, right, that we just cater to every business need, but you have to have an environment whereby businesses can thrive. There's limits to certain liability. And if you don't, it's going to make business really expensive. And look, we live in a great country where businesses are going to move. Right? If there's a better business climate, certainly in a warmer climate, I'm not sure why we would be shocked if these businesses and individuals move their facilities, and that obviously impacts employment. So that's all at risk, because you have to have a court that's not viewing this, again, from a values perspective. You have to be viewing this, what's the law? Did the legislature have a rational basis for doing it? And if they did, whether you like the policy or not, that's not your job as a court, right? You're there to certainly, if there's an unconstitutional provision, to overturn an act in that scenario. But if there's not a constitutional problem, and there was a rational basis for that policy decision, it's not your job to overturn acts that just aren't, don't align with your values. And that's what's at stake April 1st.
I do like the way you've characterized it as a tort hellhole. That's a good way to put it. Hey, I got to let you go, but inspired by this conversation, I'm playing a song, Alabama.
There we go. Beautiful.
Hey, thanks for joining me, Jay Curtis. Always a delight. Very informational to chat with you. Very enlightening. Thank you so much. We'll look forward to our conversation next week.
Thanks, Meg. Appreciate it.
Have a great day.